Welcome to Talking Legal episode. I'm Praveen Gautam, your trusted marketing advisor. I help entrepreneurs and enterprises just like you to build their brand and monetize it. Today's episode, I have got a Len Watt, who is a principal lawyer of Baker Watt Law Solicitor. A little bit about Len, 25 years of his experience in liaising with QBCC from license applications in the resolutions of million-dollar building and construction disputes. Len is a trusted advisor in building and construction law solicitor. Great to have you today, Len.
Yeah, thank you very much, Praveen. It's great to be here as usual. Thank you.
Great. Okay, so now let's, a lot of the viewers, we have been getting a feedback, and especially the context in this context, the viewers are asking, we have got a number of the clients I'm sure you would have dealing with right now, terminating domestic building contracts. Very much, topic on demand, I would imagine.
Yeah, look, it's one of those things where I have seen a number of these types of things come across my desk in recent weeks. They seem to be, I think, a breakdown sometimes in communication, and then coupled with the stress that people are feeling in the current climate, and what is possibly just a slightly off-center relationship between a builder and a consumer seems to spiral out of control, and all of a sudden we end up with the termination of a contract, potentially or sometimes validly, but more often than not, from what I'm seeing, invalidly, which can be a problem.
Yep, totally. So let's get into it today, and that's why we just thought probably the viewers who are watching this right now from different channels, including Facebook, Instagram, LinkedIn, and obviously we have got a special channel, Talking Legal YouTube channel. So if you're watching this and if you haven't subscribed, just go to our YouTube channel at Talking Legal and subscribe so you would be a first one to notify. So let's get into it, Len, if that's okay.
Sure.
So can consumer terminate their building contract if they are generally not happy with the builder?
The answer, and the short answer, is no. So a contract is a binding agreement between the parties for the construction of the home. So the consumer has obligations to the builder, including the payment of the invoices, etc. And the builder has obligations to the owner, including the quality of the home, the time for construction, and the general warranties that are provided by a builder, including the statutory warranties. However, a contract can be terminated on the basis of what we call a substantial breach of a contract.
So the answer is literally, unless there is a breach of contract, no.
Yeah. So unless there's a substantial breach of contract, the answer is no.
Okay, so now that's a little bit technical question, which I would understand. So what is the mean of substantial breach of contract, Len, please?
Okay, so a substantial breach of contract is generally something. So a contract, if you look at a contract in its most basic form, it's an agreement between two people. To simplify it to an everyday transaction, walking into a shop, asking the shop attendant for an item, such as, say, a can of Coke, exchanging money for the Coke is the formation and completion of a contract. You're asking that person for a can of Coke, they're offering it to you for a price, you're paying that price, they're giving you the can of Coke, and you leave, everybody's happy. That's, in its simplest form, a contract and how it works. So when you get a more complicated contract, such as a contract to build a house, that there are clauses and quite a lot of different terms and conditions and warranties that go into that contract. So what a breach of or a substantial breach of the contract is effectively where one of the parties does something that is fundamentally opposed to how the contract came together. So again, trying to put it into a simple term, asking for a can of Coke, being given a lemon. Now you asked for a can of Coke, but you got a lemon. You didn't get what you asked for. you're not obliged to pay for the lemon because the other party hasn't fulfilled its contractual obligation to you. It's, I suppose that's an oversimplification of the issues, but it is, somewhat in the same vein. So an example of a substantial breach of contract in a building contract would be, for example, the owner not paying a progress payment on time, or it would be something like the builder effectively suspending works without a valid reason, or losing their builder's license, passing away. Something that means that the works aren't completed. Building a single-story house instead of a double-story house. Something so fundamentally different to what was agreed between the parties that the contract can be rightly terminated.
Yep, that makes totally sense actually. So, obviously we don't need lemon if we have ordered Coke for sure, isn't it?
Yeah, exactly. If we're talking about layman's terms, for example, I suppose the can of Coke lemon example is about as simplified as it can get. But you still have rights, and if there is a reason to terminate the contract and a real reason to terminate the contract, then this can happen. However, if there doesn't exist a reason for a substantial breach of the contract, then this can create problems for a consumer in relation to a number of issues. So,
Sure, Len.
yeah.
Now, on that note, obviously, I love your analogy how, right, I love your analogy how you are, comparing between this, between the Coke and the lemon. So just on that note, obviously, Coke would have a different flavors, right? Diet Coke, different Cokes. So considering in this situation, what does that mean exactly?
So what it basically means is that I did not get what I asked for. I entered into a bargain with you and you did not give me what I asked for. So therefore I don't have to proceed with the contract in the simplest terms. And without mentioning the names, we've recently received a decision in a matter like this where the owner purported to terminate the contract for a substantial breach and move into the house as it was at final payment stage. Now, quite a significant amount of money spent on litigation later, it's been determined that the owner was at fault by seeking to terminate the contract without a valid reason. My client, the builder, has been awarded damages in that regard, and we're now seeking to recover costs against the homeowner, which could run to a significant amount. In some respects, quite sad that it had to happen, but the builder has a right to be paid for the work he's done, particularly if, when asked for the can of Coke, he gave a can of Coke.
Yep, that's very interesting. Now, just on that note, then obviously the viewers, some of the viewers are just curious to know the consequences for terminating the contract. Suppose there is any valid reason. From a legal perspective, what's your thought on that?
So, seeking to terminate a contract without a valid reason is what we call, and I think I alluded to it before, a repudiation of a contract. So, when dealing with or when involved in a contract, what it basically means is that I have agreed to undertake obligations, and I've been given rights, and you have agreed to undertake obligation and you have been given rights. A repudiation of a contract in its simplest form means that when asked to perform your obligations, you are not ready, willing and able to do so. So, for example, can I please have the can of Coke? No, I'm not giving you the can of Coke. I'm not prepared to give it to you. That's a repudiation of that contract. Now, in that particular instance, you turn around, you walk out of the shop, you go to the shop next door, you buy your can of Coke. In terms of building a house, not being prepared to undertake your obligations under the contract can lead to the other side seeking and being awarded damages. Those damages can be a loss of profit, those damages, can amount to quite a significant figure when it's considered. So, sometimes, depending on the circumstances, loss of opportunity, other things that put the person who has been wronged back into the position that they should have been, but for the actions of the other party. So not being in a position already willing and able to undertake the works can have consequences. So, telling the builder that you are terminating the contract and not making a payment is a substantial breach of contract. However, saying to the builder, I don't like the colour of that wall and therefore it's a substantial breach of contract and I'm going to terminate, is not a substantial breach of contract, but rather a repudiation of the contract, reversing the onus so that rather than the builder owing damages to the consumer then owes damages to the builder, if that makes sense.
No, very interesting point you made. Now, from the viewer's perspective or from the client perspective, I'm just putting the client's hat. Obviously, when the things are ready and there is a part of things, so how would you then pretty much as a justify that it is a valid the valid payment, or who would testify the work? So I'm just curious to know. By the way, guys, it looks like Len has just dropped. However, he will be back very, very soon. If you're just again still watching this right now, we are talking about the contracting in the law. So Len looks like he is here. So we're talking about terminate my building contract. We just lost you for a moment.
Yes. You were just asking me a question.
Yeah, I was just getting back to the questions. So from a consumer perspective, right?
Yes.
When you put the consumer's hat, obviously there is an installment of the payments, and as you just mentioned, the contract need to be very, very clear. But one of the things which always asks is who would check those, the different terms, different stages, and if they are not happy, all those sort of all those rules or all the obligations need to be very clearly on the contract, Len?
Look, I mean, a good question, and there are two answers to that question. Number one is that in Queensland and in New South Wales, Victoria, there's legislation which tells us what needs to go into a domestic building contract, particular terms and conditions. There's also a body of common law that sort of says that particular terms and conditions need to go into a contract. And lastly, if there is any doubt, then you probably need to talk to your lawyer and get them to have a look and explain to you exactly what you're entering into.
And that's the point where the legal team need to be involved or go through the contract, yeah?
And the more complicated the contract, the more there is a need to just make sure that you're aware of what your obligations are. As house construction gets more complicated, and then you start to move into different types of construction, so the contracts become more complicated. And as you move into those more complicated types of arrangements and contracts, then obviously it's important to understand exactly what you're entering into when you do enter into a contract.
Yeah, and that's where I can see that it's not just providing the legal solution for the sake of legal solution. And I think one of the point of difference is for you is being a trusted legal advisor, the focusing on a particular problem to solving it rather than just unnecessary legal solution. Yeah.
Yes, and I mean, I act for a number of builders as well, obviously, and quite often with my builder clients, we sit down and we work out in as plain English terms as we can, the other special conditions which the contract allows for, which clarifies some of the slightly ambiguous parts of the contract, and we try to make it as clear as we possibly can. I'm lucky in that with most of the builders that I work with, they look to actually work together with their customers to get the best result, which it makes my life easier because they're not looking to enter into a fight. They're looking to go out, build a house for everyone to have a good experience, and then for everyone to move on happily.
Totally. Now, thank you so much for a great insight, Len. I hope all the viewers who is watching this right now from different channels, if you like this, the heads up or the advice from the Len, gives a thumbs up, comment, or if there's any specific questions you have, feel free to ask Len and his team. And those people who would like to know more information or they have some issues right now, what do they do, Len?
So they can give us a call at 1300 at legal. So that number works in obviously Australia-wide. There's also info at beckerwatt.com.au, which is our email address that you can reach us on. And finally, through our website, you can request a consultation, and one of my team will certainly get back to you and organise a consultation, and then look to work out what the next steps are and move the matter forward or solve whatever the issue may be.
So would that be right in saying, is there be even that might be small building construction, or that might be fairly large project? Are you happy with case by case?
Look, I mean, big, small, we look to help with them all. If someone is building a house and they're a little bit concerned about their contract, come in, we'll sit down, we'll go through it and discuss it, and potentially help write some special conditions if that's what we need to do. In the case of a larger, more complicated contract, obviously we can do a fully fledged contract review and provide proper and detailed letters of advice to certainly make sure that our clients understand the exact nature of what they're getting themselves into, and conversely, we can help draft those particular documents as well. Yeah.
Spot on. So, which also means obviously throughout not just the Queensland and Brisbane, but also throughout Australia, right? Your team could be able to go through the contract, and I would imagine you have got 20 minutes initial consultation as well as an hour to book the session with your contract team, legal team. Yeah.
Yeah. So what we look to do is we look to step people through the process in a hopefully a logical and orderly fashion. So initially we will set up a initial consultation, which is either 20 minutes or an hour. So there's a small fee attached to that, $99 for a 20-minute consultation and $149 for an hour. We then, I suppose, we don't, unless it's something very, very simple, we generally are not looking to solve the problem then and there. If it is something very simple, quite often we'll just solve the problem and the person walks away. But when it's a more complicated matter, we do need to then get more information from our client. We need to properly review that information, and we need to look at and determine what the issues may be and what the resolutions may be, and then put those things in place and assist the client to move forward with looking to resolve those issues.
You bet, and that's where the Becker Watt comes in, because you have really a point of difference in building and specializing in building and construction, and with you and your team. Obviously you have got a full service, but specializing in building and construction, and those viewers who are watching this right now, obviously they can get fixed, or they can get a second opinion, if you like, on the building contract. All right, anything you like to add here before we wrap up for today, Len?
Look, I suppose I'd just like to reiterate that it's important to understand exactly what you're about to enter into. So, don't, as a consumer, you should never sign a contract, particularly worth, several $100,000 without understanding what it means. So if you don't understand, seek appropriate legal advice.
Thank you so much, Len. It was It was great insight. I appreciate your time, and those viewers who are watching this right now, yeah, feel free to like or share or comment. And if you have a specific question, reach out to Len and his team. Yeah, and thanks for watching. I'll see you in the next one. Bye for now.
Thank you so much. Thank you very much.